Well, good evening, everyone. Welcome to our Explore Lakes with New Hampshire Lakes webinar series. And tonight you are all tuning in for the Keeping the Family Lake House in the Family. And this is a hugely popular topic. Thank you to all of you who are tuning in this evening. I know that many of you are longtime webinar followers. We have a lot of new folks in the audience this evening as well. So thank you everyone for joining us. Those of you who have been with us for the past year or so, I think this is our 25th webinar. You know the drill, but I wanted to go over a few meeting management items. This meeting is being recorded. Participants, attendees, you will be muted for the duration of the webinar. We have a really big audience tonight, and it would be too much of a crazy party if we could all chime in. You are welcome to leave your camera on. Just remember, if you do, others can see you. And if you're having bandwidth or connection issues, the experts tell me if you turn off your camera, you might have a little bit better luck. So please do submit your questions during the session into the chat box down at the bottom there, the little cloud with the 3 dots. Direct your questions to everyone, and myself and my colleague Martha will answer questions if we can, but most likely we'll be saving those questions and packaging them up for our experts at the question and answer session at the end. So tomorrow you will receive an evaluation form from us. Please let us know what you thought of this evening and let us know what you'd like to learn about in the future. You'll also receive an email from us with links to this, the recording posted, the slides posted, as well as links to upcoming meetings as well. So for those of you who are new to us, I wanted to take just a few minutes to let you know who we are. New Hampshire Lakes, we are the only publicly supported nonprofit organization working to help keep all of New Hampshire's 1,000 lakes clean and healthy, lakes that no doubt you love and are very important in your life, and why you've tuned in this evening. So I'd love for you to visit our website, learn more about what we do, and take some time to make a donation and support this great work. Without your support, we wouldn't be able to bring awesome programs like this to you all. Our mission, simply put, is to keep our lakes clean and healthy so we can enjoy them today, and so our kids and their kids can enjoy them in the future. And we work with partners. We promote clean water policies and responsible use of our lakes. Basically, we're trying to inspire people and give them the tools and the knowledge to take simple actions to enjoy the lakes they love and also keep them in a state that people can enjoy them going forward. If you know us, you may know us from our courtesy boat inspection program. In the middle there, we run the Lake Host program, and this will be our 20th summer, and over the past 19 summers, we've met 1.2 million boaters at about 100 of the most highly used boat ramps in the state, teaching boaters the simple things they can do to keep our lakes free and clear of invasive species like milfoil. We also play a very important role in advocacy. We have a policy advocate who works in the State House with our representatives advocating for rules and laws and policies to help keep our lakes clean and healthy. And we do a whole heck of a lot of outreach, and that's what we're doing with these webinars. We aren't able to meet with you all in public yet, but these webinars, again, it's our 25th one this evening, have been a huge success, and we're so glad you're here with us tonight. And I wanted to thank Gorponi Automotive Group. They're really helping to bring this program to you. They've been a longtime supporter of us and very generous, and really believe in making and keeping New Hampshire the great place to live and work. So if you do have any automotive needs, I highly recommend them. It's a very stress-free and wonderful experience. So your host this evening, again, I'm Andrea Lamro. I'm the Vice President of New Hampshire Lakes, and I have my colleague, Martha Lovejoy, a Director of Finance and Development here. Martha, give a wave. We're going to be moderating this evening. But our expert presenters this evening, we have Caitlin McCurdy and Christopher Paul, both attorneys with McLane, Middleton. And I'm so excited that they're here to share their time and expertise with us. So I'm going to stop sharing now. And Chris, you should be able to share your screen now.
And while Chris is getting us all set up, I'll just speak on behalf of both of us. We're very grateful to be here. Thank you to New Hampshire Lakes and to Andrea and Martha for all of their help. And we're excited to talk with you all today.
Yes, indeed. So my name's Chris Paul, and as said, I work at McLane Middleton here in New Hampshire, along with my colleague Caitlin, and we're both trust and estates attorneys in our T&E practice here. And we get lots and lots of questions from our clients who own vacation properties, whether it's at the lakes, where the bulk of our attendees and are coming from this evening, but also people that own family farms, oceanfront property, as well as other types of vacation properties, many times with the same questions. Now, I was looking through the comments a few minutes ago, and I was struck by the number of people that were talking about how long that lake house has been in the family. And I think the oldest one I saw is this particular property managed to stay in the family since the late 1800s, which is remarkable. And there's many, many families from the early 20th century. I was reading about fourth and fifth and sixth generation ownership. And I can tell you as a practitioner, that's remarkable. And so my hat's off to you folks. You've probably already got the secret sauce figured out, but I got to believe that in those stories, those things were not without challenges. So anyhow, today we're talking about keeping the family lake house in the family. Let me back up real quick. I've got to do, because we're lawyers, I have to do a disclaimer. So this presentation is for informational purposes only and is not legal advice. So as far as today goes, we're not your lawyers. We're going to give you, our best insights, but if you have specific legal questions, we urge you to talk to your individual attorneys. Estate planning or real estate attorneys generally have a good working knowledge of much of what we're going to be discussing tonight. And certainly feel free to follow up with either Caitlin or myself if you've got any specific questions about your circumstances. So as we know, particularly now that summer's fast approaching and everybody's sort of opening up their camps, if they're seasonal or their cottages, people start sort of reflecting on the years and hours of fun that, those places have meant to the family. And like this, whether modest or grand, they have sentimental value. I like to joke, this was my family's place in North Carolina, but when mom and dad decided to leave it to myself and my brothers, we all opted out because we just figured we couldn't deal with the upkeep. Now, many of you are thinking or make an assumption that your children or grandchildren are necessarily going to, perhaps want to have the same experiences you had as parents and grandparents for their children and grandchildren. But I can tell you that's not always the case. A few years ago, I came across a Canadian study polling children of parents that were contemplating leaving vacation properties to their children. And as many as 33% had said that it already had caused problems, or they anticipated problems when mom and dad had passed and they and their siblings inherited the property. And both Caitlin and I can tell you in firsthand experience that I don't think a month goes by here where I don't get a call or she gets a call from a sibling, perhaps, concerned about significant issues now that mom and dad are gone and the house has been left to them and siblings. There's all kinds of issues that arise, and we'll talk about some of those. But, first, don't necessarily make the assumption that, your children or grandchildren are necessarily going to have the same affinity for the place that you did. Now, that said, oftentimes they do, but it's done incorrectly. So without proper foresight and planning, things may not work out as planned. So that's basically the theme of tonight's discussion. So let's assume, because you're here, that you've already decided that it's important. You want to make sure that this is the place you want to preserve. And we're going to talk about the tools for develop to make sure that there's proper management and administration of the property, mainly to avoid disputes and discord amongst the family members, so that the transitions over the generations can be as smooth as possible.
Hi, Chris. This is
Yeah.
Andrea. I'm sorry to interrupt. Your volume is going in and out. I wonder if it's just a matter of getting closer to your mic or making sure your connection is plugged in.
My mic is right next to my mouth, so I apologize for that. Let me see if I can do something with volume. Bear with me for a second here.
Sure. Thank you.
Is that better?
Yes.
Okay, good. So let's posit a common situation here. So for example, I'm going to sort of weave into some of the stories that we commonly encounter. So Jack and Denise have 4 children and 7 grandchildren. The entire family for years has enjoyed the camp on Little Squam for many years. And Jack inherited this camp from his father in 1975. And just as Jack's father had, Jack and Denise left the camp to their 4 children when they passed away, assured by the children that they would be capable of managing and maintaining the property for their children to enjoy, just as they had. However, Deborah, recently, the oldest daughter, had gone through a highly contested divorce. And although she was able to retain her interest in the camp, her financial position has changed substantially. Also, Jack Jr. recently accepted an overseas position for his company, and he anticipates being there for at least the next 3 to 5 years. And finally, due to some intra-family discord, 2 of the spouses of the children do not get along and have difficulty sharing common weeks at the camp. And finally, this year at the family meeting, hopefully to schedule vacation weeks and to determine what the capital contributions for the property are going to be amongst the family members, specifically for dock repair. There was some significant ice damage last winter. Roof and septum systems are needing attention. The meeting became contentious. And so, like Jack and Deborah did here, outright gifting during lifetime, or we call it devising the property at death, is certainly an option. And it's very common, perhaps the most common option. As you probably know, there's better ways to skin that cat. By leaving property outright to children or others, fractionalizing ownership like that, generally what happens is real estate title is taken as what we call as tenants in common. And tenants in common is often a difficult way for multiple people to own real estate. It allows for one dissenting owner to petition the court to partition the property and order it sold, for example. There's, as far as the liability goes for property taxes, insurance, and maintenance costs, they're jointly and severally liable for those costs. So if somebody decides not to pay, the other joint tenant owners have to pay. They're individually and severally liable, even if someone chooses not to pay. And essentially, the only way to recover expenses you've paid on behalf of another tenant in common is to go to court. And those are the types of things that parents don't anticipate when simply devising their real estate through their will or their trust. So tonight, we're going to talk about some of the options that you might consider, or I call, potential solutions. So I think many of you have the same goals. We certainly want to protect the property from creditors of our children and perhaps dissident spouses. A common goal is to provide a management structure for so the family can have an orderly decision process, particularly in scheduling weeks and determining what people's capital contributions will need to be. There's a whole host of other considerations as well, and we'll touch on some of those as well. Another overriding goal is frequently to limit the transferability of someone's interest in the property. Now, if you just simply leave your real estate to your children outright, there's nothing to prevent them from transferring that interest to a spouse, to a third party, or selling their interest in the property to someone you don't know. Another goal of many families is to provide perhaps an opt-out mechanism or a force-out mechanism if someone chooses not to play. So these are, four overriding concerns that many families have, but there's probably dozens more. And we'll talk about that in a few minutes. Now, before we get into the substantive discussion, Caitlin's going to give us a little brief word about taxes, particularly the uncertainty of the estate tax regime and potential income tax related issues when it comes to estate planning regarding these assets.
And I'll note, I'll just underscore the word brief that's in the heading there on the title, because Chris and I could certainly give an entire presentation just on this topic, but it's an important background to have in mind when thinking about the different structures, the different solution structures, a trust and LLC, what makes the most sense. And also when it becomes effective. Are you going to do a lifetime gift and use exemption now? Are you going to have it become effective on your death? That impacts on whether the structure is revocable, irrevocable. So it kind of paints the picture for what path ultimately you might want to go down. As many of you probably know, there are two different levels of estate tax that we want to be mindful of. One is a state estate tax and one is a federal estate tax. In New Hampshire, there is no state estate tax. That means you could be Bill Gates, and when you die, you're not going to pay anything to the state of New Hampshire. Federally, there is an estate tax if your estate is worth more than $11.7 million, and that's per person. And if you are married, you actually have something called portability, which means you and your spouse can combine your 11.7, and it doesn't matter whose name the assets are in, but you can pass essentially $23.4 million. So the federal exemption is very high right now. It's important to know that under the current Biden administration and Congress, that may come down sooner. They can always lower it. And the 11.7 is already, regardless of whether Congress acts, set to sunset in 2025. So in 2025, it will at the very least come down to $5 million per person, indexed for inflation, again, still with portability, but essentially it would be cut in half. With that in mind, what that means is that some people are considering lifetime gifting, either of real estate or other assets, to use the exemption while it's still high, depending on the value of the lake house and the value of your other assets. We may or may not be concerned with estate taxes. It's also important to know that depending on which state you live in, while New Hampshire doesn't have a state estate tax, if you live in one of the other New England states or someplace else, but vacation in New Hampshire, but it's not your state of residence, it's the estate tax that governs at the state level is the state where you live. And so Massachusetts does have a state estate tax, Vermont and Maine. So again, it's important to know the rules that will apply to your situation. At the income tax level, the biggest factor that tends to impact these discussions are whether, if you're making a lifetime gift or an at-debt gift, capital gains tax. And so one factor is that under current law, assets that you hold in your estate at the time of your death get what's called a step up in basis. And so any assets that are in your estate when you die, even if you bought them for $100, they will get a step up in basis to whatever the fair market value is at the time of your date of death. This is important if you think your family is going to sell that asset, because then they will not have a capital gains. However, it's sometimes less of a factor here in the family legacy property, as Chris was saying at the beginning. Obviously, if you've owned the property since the 1800s, you have a very low cost basis. But if the plan is for your family to own it for another 200 years, that's probably not the driving factor in this discussion. Family harmony, a lot of the other factors and goals that Chris mentioned take priority over taxes. So we never want the tax concern to drive the vehicle, but it's important to talk about it and make sure that it fits in cohesively with the rest of the plan. We're going to talk about three main vehicles that can serve as a solution for keeping the lake house in the family. Two of them are trust structures, so we thought it would be helpful just to overview broadly what is a trust. A trust is a legal entity that holds title to property for the benefit of one or more persons known as the beneficiaries. And the trust is managed by the trustee according to whatever we put in the terms of the trust. And so there are really two different hats that people wear, either the trustee hat, who's the decision maker, or the beneficiary hat, which means you're entitled to benefit under the trust, and whether that's use of the property or other things that we can put in there. Certain people can wear both hats. You can be a beneficiary and a trustee. You can be one, you can be other. If you're a trustee, you don't have to be a beneficiary. So it's the terminology can get a little bit confusing, but those are the important roles to keep distinct. And then the other thing just to keep in mind with trusts is that you can have different kinds. A revocable trust means that even if you set it up now and transfer assets into it, you retain control. So it's still associated with you. You can change the provisions. It remains flexible, very flexible. An irrevocable trust, in contrast, as the name perhaps suggests, is not as flexible. There are ways in New Hampshire, and that's one of the benefits of a New Hampshire trust, that we can still make modifications to it, but you as the person setting it up are relinquishing the control to do so. So there are ways for a trustee to modify it or for the beneficiaries to modify it, but generally you, as what we call the grantor, the person setting it up, no longer have control over it. You've probably heard, if you've done any kind of Googling or research into this, the term inter vivos. And that's a fancy way essentially of saying revocable. It means a living trust. You still generally retain control over an inter vivos trust. A testamentary trust is one that would become effective on your death, and the terms of that trust are in a last will and testament. For the trust structures that we are going to talk about, these would be standalone documents. They would not, even if they don't become irrevocable or they don't kick in until you pass away, we wouldn't recommend a testamentary trust. It means it's going to be administered under court supervision and will be a public record. And so while it's important to know the distinction, not likely to be a solution that you would use in this particular case.
Thanks for that. Just a brief note on estate taxes and state estate taxes in particular. One thing that surprises a lot of our New Hampshire clients is sometimes their estates are liable for taxes in states in which they don't live. So for example, if you have vacation property on the Cape and you live in New Hampshire, the estate may be liable for non-resident Massachusetts estate tax. The same's true if you own property in Vermont or Maine. In fact, New Hampshire is the only New England state without a state estate tax. And to Caitlin's point, you don't want the tax dog wagging the estate planning tail, but it's good to have all of the information so that estate tax considerations can be factored into your plan. And frequently, when you're planning on disposing of a specific asset like a lake house or a vacation property that may have substantial value, tax considerations may affect part of that transaction. So it's typically a good idea if you're contemplating, protecting or preserving the family cottage or the camp, that it's part of an integrated estate plan, because other factors may affect your ultimate goals and dispositions. Also, before we get into some of the substance here, in some of the questions I had seen already, there was a reference to a book and some questions about the book. And it's a book we typically recommend to clients. It's called Saving the Family Cottage, and it's published by Nolo Press. And it was created by an estate planning attorney and his spouse, who happened to be an estate planning paralegal. So it comes at this preservation, saving the family cottage from an estate planner's standpoint. And it's a 275-page book. And much of what it talks about goes way beyond the scope of today's presentation. However, I recommend it. It's easy to read, and it's a very good primer because there's all kinds of items for consideration that frequently don't occur to parents when they're contemplating preserving the family cottage and passing it along to the next generation. And whether it's a trust or an LLC, you'll see very quickly that they can become quite complex in trying to anticipate all of the potential circumstances that may arise. And of course, every family's potential circumstances may be substantially different. And so if you're really seriously contemplating doing a deeper dive into this topic, I certainly recommend that getting that book. You can get it on Amazon. I think it's the 6th edition now that's been published, and it's quite popular on Amazon. That said, the book is written as a generalist for all 50 states, and both trust law and LLC law are very state specific. And part of the book, I know that it's been a while since I've looked at it, but they rank sort of various types of vehicles' effectiveness for preserving and transferring property to the next generation. And they lean heavily towards using the family limited liability company approach as opposed to using a trust-based approach. And actually in New Hampshire, many of the, according to the book, many of the disadvantages of using a trust don't exist here in New Hampshire. Our trust code happens to be one of the most progressive in the United States. And we have lots and lots of tools in our trust toolbox that makes these very, very effective devices. And similarly, we're the only state in the United States where LLCs are not disregarded entities as far as the taxing authorities are concerned. And although New Hampshire is a very low tax state, ironically, they actually can tax LLCs directly, whereas the federal government does not tax LLCs, only taxes the members. So some of the advantages of the LLC that's described in the Family Cottage book don't necessarily exist in New Hampshire, and some of the disadvantages regarding their position on trusts also don't necessarily apply here in New Hampshire because of our very progressive trust code. So that said, the nice part about that book, even though they couch most of it in the LLC concept, the various concepts and the items for consideration are applicable whether the appropriate structure is a trust or a family limited liability company. And so, again, I highly recommend it. It's a very good primer on the subject. So I'm going to first start with what's called a qualified personal residence trust. And this is a lifetime or an inter vivos irrevocable trust. And it's created by the grantor. That's the person that puts assets into the trust. And so what is it? It's a highly specialized trust. It's used for estate tax planning purposes. And it allows the grantor to put their personal residence or their vacation residence into this trust for a specific term. What the trust allows is for the grantor or the grantor and the grantor's spouse, they would each create their own qualified personal residence trust if there's joint ownership of the family vacation property into the Cupert, Qualified Personal Residence Trust, and they retain what's called a life estate or an estate, at least during the term of the trust. And there's some potential estate tax benefits for that. And I'll talk about that in a minute, but essentially this technique is not necessarily a long-term transfer strategy in and of itself, but allows for some estate tax planning to get the asset out of the taxable estates of the grantors and use up less exemption during their lifetime than would otherwise occur at death. So let me give you an example. Let's use Joan as the sole owner of lake property, creates their Cupert in May 2021 with a 7-year term, and funds it with the lake house worth $2.5 million. So based on Joan's current age, which is 76, and the current Internal Revenue Code interest rate for May 2021, which is very low, the value of the reportable gift to her children is 1.5, a little more than 1.5 million. So the remaining value of that $2.5 million property essentially gets passed along to the beneficiaries estate tax free. Now let's fast forward, and at the end of the 7-year term, let's just say she decided when the 7-year term's over, I want my kids to own the property outright. And let's say hypothetically that property appreciated from 2.5 to say $3 million. So Joan only had to use $1.5 million of her lifetime estate tax and gift tax exemption and effectively transferred a $3 million piece of property to her children. So it's a tax efficient way to get assets out of, particularly these types of real estate assets, out of somebody's estate. And I'll talk about some of the other uses of this Cupert, but what it does do is it provides asset protection. So during the term of the trust, it's protected generally from the creditors of the grantor. And when the term of the Cupert expires, if instead of going outright to the children, it goes in trust for the benefit of the children enjoy asset protection as well. Now, there's a lot of technical requirements to create a Cupert. I'll give you an example. This is a famous book. I don't know if you can see it on my camera or not. There it is. It's called the Cupert Manual. It's published by a Boston lawyer. It's the Bible for people that do Cuperts, and it's 300 pages long, and it's full of very technical IRS requirements. But don't let that scare you off. It's a very common estate planning technique used by hundreds and hundreds of our clients, and very successfully. Now, during the course of the term of the trust, the grantor, the person that puts the property in the trust, gets to use it. Now, they also, for the privilege of using it, get to pay the property taxes, insurance, and general maintenance costs during their lifetime. When the trust expires, we typically prepare our Cuperts that allows the grantor to continue to live in that property. The catch is they have to rent it now from the trust that holds the property for the benefit of their children. And again, a lot of people think that's a great strategy because maybe by the time this Cupert expires, the grantors still want to live there, still want to pay the expenses. So instead of paying expenses directly, like they did during the term of the Cupert, they now pay rent to the trust, and the trust pays all those expenses. So it's a way of the grantor continuing to pay expenses, but now because it's rent, they're essentially making tax-free gifts to the children without using up any of their estate tax lifetime exemption. Now, there's some disadvantages. If the term of the Cupert is longer than the grantor survives, it's as if the Cupert never happened. That asset gets dragged back into the grantor's estate. So the length of the term is important. There's always mortality risk, and some people think that the technical requirements of creating a qualified personal residence trust are just more than they're equipped to do, or there may not be an estate tax issue with that particular client. So without the potential for estate tax benefits, typically Cuperts don't have much value. But that said, if there's an estate tax planning component, we frequently use qualified personal residence trusts as the first step in the long-term transfer of the property using a family compound trust or a family limited liability company. So it's used often in conjunction with that preservation, but it gets some additional estate tax benefits to the grantors. Next, I'm sorry, Caitlin, I was just going to say next, once we got through the tax and the family compound, the Cupert style, which again is a very common technique, oftentimes we'll have the Cuperts empty into the new family compound trust. And we're going to talk in depth about family compound trusts and limited liability companies as the potential vehicle here. And Caitlin's going to lead the discussion here on the FCT.
Thank you, Chris. And I was laughing to myself because I commented to Andrea when we did the test earlier today that despite having done virtual Zoom meetings now for a year, I inevitably start talking while still on mute. And hence you all have now gotten to witness that in person. So as Chris said, the Cupert is really, if we want to leverage and maximize your use of your estate tax exemption, it's a way to get a discount so that you use less than face value on transferring property. However, it's really not intended to serve as an overarching or long-term governance structure for the trust. And that's where the family compound trust comes in. It's really the purpose of the structure is to facilitate the ownership and management of family, what we call legacy property. You intend for it to stay in your family for at least a generation, hopefully many generations, depending on the family goals. And within that sort of ownership structure, if you have multiple children or multiple siblings, it provides for organized decision-making, annual meetings. It outlines how the owners come to decisions, who has voting power, how much voting power they have, how you pay expenses, how you collect assessments, and importantly, whether there are future restrictions on who can own the property, who they can pass the property to, and sales and all of those components that go into, as you all know from owning and enjoying lake property, all of those factors that we have to think through when we're thinking through keeping a lake house in the family. So the potential estate tax benefits, there is a way to incorporate gifting and use of your exemption with a family compound trust, although that's generally not the primary purpose. And this goes to, you can always create a family compound trust during your lifetime and transfer the real estate into it. You can keep it revocable so that you can change the terms during your lifetime and what the provisions are going to be. And then it becomes what we call irrevocable on your death. And that's when what we call the certificates of beneficial interest, so the CBIs, the owners, it's at that point that the CBIs could go out to whoever you want those shares to go to. Or you can have the family compound trust be irrevocable from the beginning. You say, I know what it's going to look like. My family structure isn't changing. And I'd like to give it over time more slowly. And so you can set up the trust. It can be irrevocable from the beginning. You can transfer the real estate into it. And then you can slowly gift the shares over time or do it all at one time, depending on whether you have exemption left, whether we're going to use your annual exclusion. So there are ways to combine it if that is desired. The organizational structure, again, the big piece is the CBIs, who are going to be the beneficial owners. It can be, a typical example would be if you have 4 children, we would do 4 classes of shares, an A share, a B share, a C share, and a D share. Each child would own their class of shares. And generally the child would be given some control over who their class of shares go to. So generally it would be their children. Again, family dynamics can make this play out in a million different scenarios. But typically the idea is that it will honor and create an organizational structure for the different branches of your family. It's a way to keep the branches equal if there are different numbers of grandchildren, right? It's easy to think through, we'll call all of you Gen 1, right? You're the owners of the property. You're thinking about passing it on to Gen 2, who are your children. We don't always know how many Gen 3 members there are going to be for each family branch. And so the classes are a way to say, we have 4 branches and they're all going to get equal say, even if one child only has one child and another child has 4 children. And a really big, important factor, but also what adds complexity and makes it difficult to answer specific questions in this universe is that it's flexible. So if that's not right, if you don't want the 4 branches to have equal say, if you want all grandchildren at Gen 3, then we design it differently. But those are the sorts of the ideas that we have certificates of beneficial interest, and we want to identify who gets them, how they get them, and what power comes along with that so that it accurately reflects what you want and how your family dynamics work, who uses the property, who you anticipate to continue to use the property. Typically a CBI will have a voting right. So sometimes the class, right, the A class all has to vote together and then they cast one Class A vote. Sometimes every share is a voting share. Again, it depends on your family circumstances and the goals for the trust. A big factor of most family compound trusts is that we put restrictions on who can own a certificate of beneficial interest. And so it's important when we talk through this, and we are very frequently drawing family trees to make sure we understand who is involved, who's supposed to be involved in the future, and sometimes more importantly, who's not supposed to be involved. And so sometimes spouses of children are allowed in. Oftentimes they're not. The idea is that you want it to follow your kind of blood lineage or adopted issue. And so talking through who can own them and how they can own them is an important part of this. Another important part is that generally we restrict your ability to sell your CBIs. So you can gift them to family members, you can sell them to family members, you generally can't sell them to third parties. And that's a way to keep the ownership structure within the family. If one branch wants to get out because they've moved to California and they're not using it anymore and they don't want to have to pay in, they can gift or sell to family members. Again, we can modify all of this. Really, the world is your oyster. If you don't want them to have to sell, if you only want gifting or you only want them to be able to withdraw, we can put all of those provisions in. Sometimes we say if you withdraw, you just don't want to be a member anymore, you get paid out. Sometimes you don't get paid out. Sometimes you get paid out at a fraction of the value of the real estate. Understanding that obviously that makes it harder for everyone else who wants to stay in if someone's getting paid. So it really, there are a lot of factors for us to think and talk through. And we generally, the initial meeting is a longer one to go through what happens under all of these different contingency plans. But the helpful part is that it's all built into the trust so that it's clear based on what your intention and goals are, how the property should be managed moving forward. The other managerial points of a family compound trust that are important are how we pick the trustee. And so again, that's the person who's in charge. Sometimes you say there's one trustee from each class. So right, each child can be a trustee. Sometimes you say the children all vote on one trustee or 2 trustees. Sometimes it makes sense to have it be a family member. Sometimes it makes sense to have another party involved depending on the family dynamics. But we want to make sure we say who gets to pick them and who's a qualified trustee. We also put provisions in that talk about setting rules and regulations. So there has to be an annual meeting. It can be by phone, by Zoom. Obviously, everyone is now much more comfortable with those options after this past year. But it sets up the ability to do rules and regulations. You know, how do you select use weeks for the summer? Who takes out the trash? Is there security at the property? And all of that is really generally done in a separate document by the CBI holders so that it can evolve over time and we're not forced to change the trust document itself, which is meant to be really the more permanent provisions of the trust. Assessments and capital improvements is a big topic, especially as properties continue to get older and require more maintenance and upkeep. The basic example is that there's no money in the trust. Obviously, the CBI holders have to put money in to pay the real estate taxes, to pay any capital assessments. Typically, they vote on that, right? You would have to have majority or 3/4 unanimous. We can put in whatever the requirement is before the trustee can go out and put a new roof on the house. But we have to build all of those things in. And I know Chris will talk about this a little bit more in greater detail, but endowments and whether or not to endow the trust, not only with the real estate, but with some sort of liquid account to facilitate that, is another important part of the discussion. In our anecdotal experience, generally family compound trusts that are endowed with some sort of cash gift as well tend to be more successful because it takes the initial pressure off the family in terms of how they're going to pay for it. And it allows them to continue to enjoy the property, especially if you have children that are of different financial needs. What may be easy for one child to contribute may not be easy for the other child. This is where location makes sense, right? If one child lives in California, not only do they have to pay that help upkeep, but they have to pay and take time off to travel to the house. So as is probably a general rule for life, money tends to be an important part of this conversation. And another thing just to flag, because it's generally a topic of strong opinions, is if you have given an endowment to the family compound trust, what happens when people withdraw? A common answer is that if you're going to pull out, you can pull out, but you don't get paid any of the endowment, right? The idea was to give that money to continue to support the house. And if you don't want to use the house anymore, that's fine. You're not penalized for that, but you don't get to benefit at the expense of the people that are staying in. Typically, one of the features that we put in a family compound trust are dispute resolution provisions, so that if there's not agreement or there's a deadlock, there are provisions to facilitate a resolution. Because again, we don't want to end up in any sort of litigation or partition to partition. You can't do that with a family compound trust. And then typically we don't, which is to Chris's point, one of the benefits of the New Hampshire Trust Code being as progressive as it is that we don't have to put a termination date. You can have what's called a perpetual trust in New Hampshire. So we don't have to put any end date in there. It can be around for the next 200, 400, forever number of years. Typically we say if there's unanimous consensus between the CBI holders that the trust should be terminated or the property should be sold, that obviously that it does give an ending mechanism so that if it's no longer suiting the family needs 200 years from now, there's a way to undo it. Chris, any big points that I've missed on the family compound trust?
Well, nothing in particular, but I think it's important to just reinforce the notion that, you know, the people that own the property that are considering creating a family compound trust or a family limited liability company are the ones in charge. And there's a broad, whether it's a trust or an LLC, you've got sort of a blank palette, if you will. And whether we're talking about voting rights or ownership rights or transfer restrictions or a formal organizational structure or dispute resolution provisions, opt-out or force-out provisions, all of those can be drafted, can be custom designed for the specific circumstances. Caitlin was giving some good examples of common structures. I think some people refer to it as the branch structure, where each of the Gen 2 is considered a different branch and that they all have equal beneficial interests in the trust. And therefore, one branch that has lots more grandchildren than another branch doesn't necessarily have more voting interests. Other families choose to treat that and go separately from the branch system. We can design family compound trusts or family limited liability companies either way. Caitlin also raised an important point. One of the disadvantages of trusts in many states is that they have to terminate after a certain period of time. It's called the rule against perpetuities. It's left over from 12th century England. New Hampshire has waived the requirement of the rule against perpetuities, so we can have perpetual trusts in New Hampshire. And in some cases, people that own property in states outside of New Hampshire can put their out-of-state property into a New Hampshire trust, and in certain instances may be able to avoid the rule against perpetuities in their home state. We didn't talk much about opt-out or force-out provisions. These are custom drafted typically, but oftentimes there's a mechanism in a family compound trust where if someone habitually doesn't pay the capital contribution, they're forced to sell their interest back to the trust itself, so that the trust acquires the dissident CBI holder's share, and then the remaining owners, all benefit from, I call it owners, enhanced ownership. One of the things I want to stress, and I'm a victim of it too, when you're a beneficiary of a family compound trust, you don't own the property that's in the trust. When you're a member of a family limited liability company, you don't own the property that's in the limited liability company. Your only rights and interests are defined in the documents themselves. So typically our family compound trusts don't give anybody specific ownership rights, but they do give them occupancy rights. And so the deal is they get to use the property. They don't get to sell it. They don't get to pledge it if they're in financial trouble. They don't get to necessarily sell it without, depending on how the trust is designed, without comporting with the terms of the trust. And again, if we have a dissident member or someone that violates, some significant policies, runs an illegal operation out of the house, or, contributes to underage drinking, or who knows what those triggers might be. Again, they're all custom designed. There may be a mechanism to force that person to sell back to the family compound trust their shares. Now, it often comes up is, well, wait a minute, the trust doesn't have a lot of money. And so how are they going to buy out somebody's 25% interest? Where are they going to get the funds? Well, typically, whether it's a family compound trust or the family limited liability company structure, what we call sometimes the call option. In other words, the managers or the trustees get to say to a member, you've been voted out. We're going to acquire your interest, and we're going to buy it at a discount. And we're also going to buy it over time. So typically what would happen is the family compound trust would issue a promissory note in exchange for that person's interest and pay it over time. Often that's true with limited liability company interests as well. So I saw a question earlier about financing, and maybe this doesn't specifically address that question, but I can tell you that in my experience, whether it's a family compound trust or a limited liability company structure, getting financing on the property or transferring a specific property that's encumbered by a mortgage is problematic in many cases. Lenders who typically, lots of lenders who write conventional mortgages typically sell them, and they get either guaranteed by the federal government, Fannie Mae or Freddie Mac. They get bundled into securities and sold. And so those mortgages have very strict technical requirements, and ownership by an LLC or a family trust does not qualify. So you need a lender that typically hangs on to their own loans. In other words, keeps at least a portion of their lending portfolio on their books. And Oftentimes it's credit unions that have sometimes the most flexibility. But if you think about it, if somebody's lending money and has a mortgage on a house, the lender wants two things. They want to know, A, that they're going to get paid, and B, how do they foreclose in the event the note doesn't get paid. And so both trusts and LLCs in this state allow for the managers or the trustees to pledge trust property as security in exchange for a loan. So that's not a technical hurdle, but the bank still is often not satisfied because particularly if the trust or the family compound, the family limited liability company is not renting the property and generating any income, the bank's going to say, well, how are you going to pay for it? And usually what ends up happening is that the existing owners often will pledge personally that they're going to pay the note if the trust doesn't. And that's often enough to give the bank comfort, assuming that the existing owners are creditworthy. So in order to avoid having to finance the property if there's a call option exercise and a member is being expelled, again, we typically build into these structures long-term payouts so that the existing members can chip in annually enough money to pay the mortgage interest and principal for the exiting member. And Caitlin touched on it earlier. Oftentimes when there's an expulsion, if you will, the trust has the option to buy out that member's interest in exchange for that expulsion. But generally speaking, there's a penalty so that, if the property is worth $2 million and hence a 25% beneficial interest is theoretically worth 25% of that or $500,000. Oftentimes, because of what we call valuation discounts and other reasons, the call option may only pay 75% or even 50% of the fair market value of that 25% interest. So it often encourages, good behavior. Now, that said, a beneficiary may be a good citizen, but has, in my example, moved to Europe and just says, look, I don't know when I'm coming back, and I'm probably never going to use this place. So I really would like to find a way not to have to pay for the annual assessment. Now, some families say, okay, you're allowed to sell to anybody in your branch. Other people, particularly those that don't have the branch structure, may say you're allowed to sell to anybody who's a CBI holder already and is an eligible person to be a CBI holder without having to worry about approvals from everybody else. And this is a potential exit strategy for somebody that just wants to opt out. Other times we have more formal mechanisms where, again, the trust or the LLC will buy out the exiting member. And oftentimes the discounts or the penalties are not nearly as great. I see a lot of family compound trusts where sales between siblings or others who are in the same branch are okay with, the trust structure. And sometimes it may be that the opt-out grandchild just wants to give his interest to his siblings rather than sell it. Or alternatively, there's nothing in the agreement that requires a specific sale price. Again, we can custom design, and we do custom design these documents given the various family circumstances and the options they choose. One other point, and I should have said this earlier, when Caitlin refers to CBI, when people look at our family compound trust or a typical family compound trust, it looks an awful lot like a limited liability company agreement. Those of you that are familiar with LLCs or even corporations, owners of that entity usually receive a certificate of stock ownership or a membership interest in an LLC. And in terms of a family compound trust, the beneficiary gets what's called a certificate of beneficial interest, or CBI. And it talks about their percentage of beneficial interest in that trust. There's 4 beneficiaries. They may all have a 25% beneficial interest. As the family branch expands, those 25% interests may get fractionalized, but it's still, each branch has 25% if we're using the branch structure. So again, one of the disadvantages cited in the book that I referred to earlier is that trusts are inflexible and LLCs are much more flexible. That's just not true in New Hampshire. That may be true in other states, but we have the ability to prepare family compound trusts with all the bells and whistles that modern limited liability companies have without necessarily some of the potential disadvantages of LLCs. And I'll talk about that in a minute as well. But other things we spend a lot of time discussing with clients is who gets to vote on what. In some cases, trustees may control much of the activity that goes on within the operation of the trust, including setting annual assessments, deciding what the capital reserve fund will be, determining what the vacation schedule will be. And in a branch structure, that often works well when each branch is fully represented on the board of trustees. In other cases where there's a host of individual CBI holders, sometimes it's not as efficient to convene the entire group. A good example is I just completed a family compound trust, sort of restated an old one where the members or the beneficial interest holders of this trust, now there's 48 of them, and they all have equal ownership now. And so there's 48 equal voices. Well, that's a difficult group to manage. So they've decided amongst themselves what their trustee structure is going to be. And while they annually they get to vote who represents them in their capacity as beneficiary, it's not as unwieldy a group as having 48 people sitting around a conference room voting on stuff. I can tell you that was a complex endeavor, but right now it looks like it's going to be successful. Back to Caitlin's point about endowments, we had a question, and I think it came directly from the Saving the Cottage book. It has to do with, there's a whole chapter on endowments. And so the first question is, what is an endowment? Well, first of all, I think endowment's not quite the right technical word because endowment has some meaning from a legal and tax standpoint, but it's nice to think about it as in terms of, a resource or a source of money, whether it's in the trust or it's outside of the trust, but designed to support the trust, that allows for a lot more flexibility, particularly amongst families that might have children or grandchildren with wildly disparate incomes. One may be a school teacher or a social worker, and another may be a physician or hedge fund manager. And obviously, given the different financial resources amongst children, sometimes endowing the property, either during your lifetime or when you pass away, leads to a lot less stress and discord, particularly for those family members that might not have as much income as others. It allows them to participate fully without having to worry about meeting annual capital calls. And to Caitlin's point, in our judgment, most of the time, the most successful preservation strategies come with some endowment that relieves a little bit of financial pressure from the future beneficiaries. An endowment's established typically by opening a bank account or a brokerage account in the name of the trust or in the LLC, and usually those funds are managed by the trustee. Now, certainly the trustees can rely on financial advisors to help them invest the portfolio wisely. Same with limited liability company managers. They can do the same thing. There's a question here about the size of the endowment, and obviously that depends. It depends on the financial wherewithal of the future generations. It depends on the operating expenses, surrounding the property. Obviously, if the house is in New Hampshire, we know that property taxes can be, significant. And so simply planning ahead for, how many years you think your endowment should be there, used to support or partially support the operation of the legacy property, will determine, the potential size of the endowment. There's one question here: how do heirs feel about the endowment? I think it depends. It depends on the family. So, in a typical branch structure, let's say Gen 2 is 4 Gen 2 members, and one Gen 2 family member has 4 children, and one Gen 2 family member has none. Well, theoretically, the Gen 2 family member that has none says, well, I don't use this property very often, but mom and dad's money is using to support it. So my sister, who has 4 children, is getting much more benefit from mom and dad's money than I am. And sometimes that can lead, to potential problems. I typically say, geez, you're looking a gift horse in the mouth. But in theory, if mom and dad decide to endow the family compound trust or limited liability company with $500,000, say, that's $500,000 that is not in their typical will or trust that would otherwise perhaps flow to the beneficiaries directly. So ordinarily, I think endowments are well received by the heirs, but there's a potential fly in the ointment when it comes to that. Somebody asked about what's the end of the endowment? Well, the end of the endowment is typically when or if the property is ever sold. If the property is sold and the proceeds in that case would then be delivered to the trust, and a typical trust or LLC would have a mechanism that says, now that the property sold, this entity no longer has a purpose. So we're going to distribute the property that's in the trust outright to the people that hold beneficial interests or shares of stock in the corporation or membership interests in the LLC. So at the end of if the trust is terminated for whatever reason, the proceeds that come from the sale of that property are distributed pro rata to whatever your economic interest happens to be in the entity. And how's an endowment used and how's it managed? Well, the endowment can be used however the person creating the endowment decides it's used. So there can be very strict rules of the road, or it can be left up to the trustees, or a combination of both. They can put some guardrails up there and say it can only be used for property taxes, or it can only be used in an emergency or what have you, or it can be wide open, left open to the trustees or the managers. And how's it managed? Obviously, that's circumstantially important as well. $500,000 plus endowment is not chicken feed. And, if I were making that endowment, I want to make sure that the people in charge of investing it and managing it are doing so prudently. So I may decide that in that case, a wealth manager or someone with experience managing assets like that would be in charge of investing and relieve the trustees if they don't have that kind of expertise from that experience. So brief word on endowments. For some reason. Anyway, I just want to reinforce the point that the qualified personal residence trust and family compound trust or limited liability companies are generally used in conjunction with each other. The Cupert alone is not the asset preservation strategy for the long term. It's just an estate tax play. I want to talk about family limited liability companies. And I can tell you historically, because we have this anomalous LLC structure here in New Hampshire, we're only one of 50 states that taxes limited liability companies at the entity level. They generally were looked on with disfavor in Massachusetts, while the family compound trusts we do in other New England states are often LLCs. And I call them family limited liability companies because you can actually have a limited liability company in New Hampshire without, or in any state that isn't really a business. Even though it's technically a business entity, it doesn't have to have revenue and it doesn't have to show a profit, much like a trust. Now they're taxed a little bit differently if there is revenue, but generally speaking, even family compound trusts or family limited liability companies that rent their properties occasionally generally don't generate net income because the meager rental income they receive annually compared to the annual expenses, which offset the revenue, generally mean that neither entity gets taxed. Okay, but there used to be a couple of big disadvantages for limited liability companies that didn't exist with family compound trusts in the state until recently. Number one is there was a lot of ambiguity about this for many years, but the Department of Revenue Administration in this state came out very strongly and said a transfer from a family member to a family limited liability companies that had more than one member resulted in a property transfer tax. And in New Hampshire, that's 1.5% of the value of the property. Whereas that provision didn't necessarily apply to family compound trusts in a lot of circumstances. The other thing, potential disadvantage that still exists with a family limited liability company, it's not a potential disadvantage in a family compound trust, is that if the property ever gets sold and generates capital gain, the capital gain could actually generate a state level tax at the LLC level. It's called the business profits tax, and it's something that LLCs have to pay. Now, ultimately, if the property sold from a family compound trust, the family compound trust will very likely not have to pay capital gains. Well, it won't have to pay state level capital gains tax here in New Hampshire, where the LLC might. And ultimately, when the proceeds are transferred to beneficiaries, or in the case of an LLC, when the K-1s go out, the beneficiaries ultimately are the ones that pay capital gains tax at the federal level. So the difference really between an LLC and a family compound trust these days is that a family limited liability company may end up with a business profits tax someday in the future. But they look almost identical. The organizational structures can be identical. The dispute resolution provisions can be identical. The put and call or opt out and force out provisions can be identical. Transfer restrictions can be identical. Potential estate tax benefits, are often identical. And I just wanted to touch briefly on that. We set up family compound trusts in a variety of ways. Sometimes it's, grandpa and grandma or mom and dad that decide they want to do some advanced planning, and they create the family compound trust or limited liability company now. But they keep all of the certificates of beneficial interest or all of the membership interests in the LLC. So really all they've done is created an entity and put that asset in there. And then over time, using their $15,000 or $30,000 annual exclusion gifts, may make gifts of certificates of beneficial interest to the branches or to the individuals that they want to benefit. So there's an efficient way to get assets out of a taxable estate, not using up any lifetime exemption. I just did a family compound trust for a family where they wanted to make all the mom and dad kept an interest, and the 5 branches each got 20% of the rest. And so they made essentially, pardon me, an 80% gift of the value of the property in 2020, and got that out of their taxable estate now. And that is the benefit of making sure that any future appreciation doesn't show up in their taxable estates. And their goal is that upon their death, the remaining 20% interest that they hold will be distributed pro rata to the 5 branches. Other family members decide they're just going to create a blank or an empty family limited liability company structure or family compound trust structure now. And then when they pass away, their trust or their will conveys the property and any endowment to that entity so that it's ready to go, but it's just not funded until they pass away. Many times family compound trusts that are created during lifetime where assets haven't transferred yet, that trust, or in this case, the limited liability company, essentially remain revocable in the sense that the grantors can modify the trust or completely tear it up if they decide it's not going to work without having committed already to the transfers. So both LLCs and family limited liability companies, depending on the circumstances and depending on how they're designed, are extremely flexible vehicles and can be very, very comprehensive. Usually when we create either one of these entities, we also generally meet with the trustees or the prospective trustees and create sort of an initial rules of the road. And we make a provision in the trust or the LLC that annually when the trustees or the members meet, they can adopt new rules. So they can do anything from pet restrictions to guest restrictions to deciding what, creating a lottery so everybody gets to choose which week they're going, et cetera. And so those rules and regs can be very, very comprehensive. In this 48-person family compound trust I did, their rules and regs were extensive and had all kinds of restrictions on, making sure that the septic system wasn't overburdened and, who's responsible for what, dock maintenance. There's a boat involved with that trust as well. So, a lot of complexity that gets built into these documents. But the more foresight that goes into these things, I think the better the outcomes. And as a final kind of note on both of these types of entities, the one good thing, or the one thing we often built into these mechanisms, is the ability for future generations to amend these documents without blowing the whole thing up. And both under our trust code and under our limited liability company code, we can build those types of features in these documents that allow for families to modify down the road due to unanticipated circumstances or other potential changes. So even though these items, when you pass away, are irrevocable, there's still lots of flexibility that can be achieved. And so, in fact, this 48-person family compound trust I did was really a modification of a 50-year-old family compound trust that was just obsolete. And so we were able to, under our trust code, modify that initial trust substantially so that the new trust created achieves what the current owner's goals are. So, one other technique that's often used in conjunction with one or all of these techniques are conservation easements. And again, a brief note on this, Caitlin, if you want to talk briefly about when and how these are used.
Sure. And again, like taxes, conservation easements is another topic that could be its own standalone presentation, but especially given New Hampshire lakes, and we know a lot of you feel strongly about the environmental concerns that go along with these properties and not having them overdeveloped as well. So we wanted to note, you can have conservation easements on property that's transferred into a trust or an LLC. You can do that during your lifetime. You can encourage the CBI holders to do it after your death. Generally, if it's something you feel strongly about, it's easier to do on the front end while you're still alive in order to get all of the pieces in place. But basically, a conservation easement is a way to put restrictions on the land so that either it's limiting commercial development, industrial, residential use of the property, so that you're preserving in some capacity open space forever. And you can do that and still have your family use it as a legacy property. It just means their ability to sell it for X number its value could be limited. And so if that's important to you, it's important to us, and we can help build it into the plan.
Okay. So we've got some time for Q&A. I believe Andrea and Martha are going to either send us some questions or tee them up for us.
Oh, thank you, Chris and Caitlin. That was very informative. You guys truly are the experts, and I think we're going to need to have you back again to go into even more detail on this. We are a little bit over time, so those of you who have to leave, that is totally fine. These slides and presentation will be posted tomorrow. And what I'd like to suggest, and sorry to put Caitlin and Chris you on the spot, maybe Martha could pose a few questions, but I don't believe we'll be able to get to all of them. And maybe I can then send you, Caitlin and Chris, the remaining questions. And if you have time, I know you guys are super busy. If you have time to give some brief written answers, I can then post those or share them with the attendees later.
Happy to do that. Thanks for that.
Okay.
Sure. And one of the questions that's sort of interesting, several people had questions about how to talk with next gens. So like their children, or do you bring that up with them, and, sort of just how that gets typically approached?
That's a good question. And Caitlin and I call that having the conversation. And one of my earlier slides, I mentioned that despite what I and my spouse might think about our family vacation property, perhaps our children don't necessarily have the same affinity. And so generally I like to recommend that clients talk to their children, particularly, if they're planning on some sort of long-term preservation strategy, just to get a general idea. And I can tell you that the book I recommended has a nice chapter on that very topic. And again, every family dynamic is different. The one thing to keep in mind, though, at the end of the day, you're in charge, and it's your property. You get to design the trust the way you want it, but clearly, depending on, again, the family dynamic, that's a circumstantially specific type of conversation. And many times it boils down to having individual conversations with individual children, or, at least at best, getting a sense for, the overall temperature of the kids, and perhaps, an outline of what your thoughts and plan might be, and see if there's interest. And if not, then obviously, what happens to a lot of family camps or cottages, if there's not enough interest in the next generation, obviously it can be sold when you pass away, and those proceeds divided up amongst your kids, then maybe another family will get the same benefit and enjoyment that you've had. Very quickly, I had one question. Somebody asked me what the name of the book I kept referring to, and it's called Saving the Family Cottage: Creative Ways to Preserve Your Cottage, Cabin, Camp, or Vacation Home for Future Generations. And it's published by Nolo Press. And right now, I believe the current one is the 6th edition, and that's available on Amazon or, most major booksellers.
And Chris, I know Andrea and Martha have put that into the chat, so people have.
Oh, good.
The full.
Okay. So I guess that doesn't answer that specific question, but again, we talk about it when we have our estate planning meetings with our clients, because that's frequently on their minds.
So one other question we had is about the estate taxes, and if that's based on the giver or the givee. How did the estate taxes get assessed?
That's
Caitlin,
yeah.
you want to take that one?
That's a great question. The estate taxes are assessed at the time on the giver at the time of the gift. So if you make a lifetime gift and you're using exemption, you either file a gift tax return to report the amount of the gift. If you're exceeding your exemption, you would pay gift tax at that time. If there are estate taxes involved, those would be paid at your death.
Okay.
So it's not, the recipients of the gift don't have to pay the tax. The beneficiaries of the estate don't receive anything, though, if there's an estate tax, until that estate tax is paid, but they're not personally liable for it.
Mm-hmm.
There's one technical exception called the generation skipping transfer tax. And again, that's a day-long seminar, but in certain instances, sometimes the beneficiary is responsible for that particular tax. It almost never applies, but it can. But to Caitlin's point, when you get a gift, you don't pay tax on it. Whoever gave you the gift does.
Mm-hmm. So someone else is talking about, mostly what you were talking about this evening is property owned by one individual or a couple, but what if you're currently co-owning a property and talking about going forward with that?
That just adds complexity, but we do it. And sometimes, it's the second generation that comes to us, 3 or 4 siblings, and say, we've got this place, mom and dad gave it to us. We want to put some structure in place here. And now sometimes that's a difficult conversation to have with a lawyer. So just from a professional conduct standpoint, it's very common for people to want the same lawyer to represent the entire group. And we do a lot of estate planning for husbands and wives, or I form limited liability companies for 5 business owners. And they want one lawyer to represent all of them. And that's allowed under our rules of professional conduct. However, Caitlin will tell you that, we always have to have the conversation when we're representing multiple clients, that if there's a dispute, first of all, our fiduciary duty and our professional duty to clients is equal amongst all of the clients. And so if there's a dispute that we can't resolve, we can't represent anybody. We can't pick a favorite, and each party would then have to get their own attorney. And so sometimes it's a little tricky, but usually when we're approached by, say, the next generation, they generally have an outline of general agreement on how this thing should unwind. Now, when you get into the weeds, there's often some minor disputes about voting rights or, who gets what, but oftentimes they're easily resolved. But it is sort of a little tricky landscape when there's more than one client.
Someone else was asking if the Cupert affects the step up in basis.
Caitlin?
That sounds like a Caitlin question.
The short answer is yes. Typically, again, there are exceptions to exceptions because lawyers like to make themselves necessary for these discussions. But if you're making a gift, the tax basis is called a carryover basis. And so when you transfer the real estate into the Cupert, the beneficiaries will get your tax basis rather than a step up in basis. If you own things and the assets pass at death, then you'll get a step up in basis rather than the carryover.
That said, the step up in basis at death in our tax code has been around since 1954, at least. It's in jeopardy. The Biden administration has proposed getting rid of that feature. So whether you give the property away during your lifetime or at death, there won't be a step up under this new proposal. And essentially what the law says is if you pass away owning assets, then it's as if you sold every asset the day you died, and capital gains tax gets assessed as of the date of death. And so the benefit of achieving a step up in basis at death may be on the short list. So that's an issue that's in flux.
And again, it goes back to the main goal. Do you think your family's going to sell it? How quickly do you think they're going to sell it? Because if the intention is really to preserve this for generations to come, the capital gains tax and your basis only come into play when you're selling the property. And so again, sometimes that's not the most, while it's important to know, it's not necessarily the most important factor to plan around.
Someone else was asking if their property gets put into a trust or one of these vehicles, do those trusts have to file taxes annually, or is there some responsibility with that?
Just like Caitlin said, the answer is it depends.
Oh.
Now, LLCs generally have to file what's called a Form 1065 federal form and perhaps a state tax form annually if they have enough income to meet the filing thresholds. Okay. LLCs do not pay tax to the federal government, even though they file a Form 1065. They don't owe tax, but the members who own shares in that LLC do. So if the LLC generates income, it reports that income to the federal government, but tells the federal government everybody's social security number who owns shares in that company. Trusts are taxed differently than LLCs. And depending on the kind of trust and its status, the trust itself may be liable for income taxes at the federal level if it's got enough income to generate a return requirement. Or alternatively, if a trust, it's not talk about a family compound trust, but let's say a generational trust from grandma and grandpa, has $5 million in it and it generates $500,000 worth of income. Either the trust would pay taxes on that income, or if the trust makes a distribution to the beneficiaries would pay tax on that income. So there's no real hard and fast rule. Do trusts pay income tax or LLCs? It depends on the circumstances, but it's possible. Now, in a family compound trust or a family limited liability company that doesn't have rental income, there's no tax to report because there's no income to report. And so in that case, while there may be an informational return required, there's not really any heavy lifting for the CPA to do every year.
So Lisa's asking if she's been advised to create a family land preservation trust and was wondering how that's different from a family compound trust.
It might not be any different. I need to know more, but we just happen to call our trust the family compound trust, and that's been somewhat ubiquitous here in New Hampshire. Now, a family or a land preservation trust may have a different purpose. It may be endowed in order to actually preserve property specifically. That's not necessarily meant for occupancy by the next generation, but not knowing more, it may be that that particular estate planning lawyer just happens to use that terminology if we're talking about the same concept.
And it could be, to Chris's point, depending on the recommendation and the background, that it's some combination of what we were referring to as a family compound trust with a conservation easement or a preservation easement incorporated into it.
Oops. Sorry, I've lost my volume for a second. Let's see. Andrea, I'm not sure how many more questions you want to do. Or
Yeah. Well, we're right at 8:30, and I see that folks are starting to leave. So I think, why don't we call it a night now? And then again, Chris and Caitlin, I will follow up with some of the unanswered questions. And when you have the time, you can respond, and then I will post those and share them with attendees. So this has really been wonderful. As someone who, my family has a home on a lake and my husband's family has a home on the lake, and we have a lot of figuring out to do, and this has definitely been helpful. Oh, thank you. And I really appreciate you both sharing your evening with us, and to everyone who tuned in and shared their evening. So Chris and Caitlin, any last words of wisdom or recommendations to our crowd here tonight?
No, not really. I just want to thank New Hampshire Lakes and of course all the attendees today. This was a nice opportunity to talk about this. It's obviously got a lot of interest, and so we thank your organization for hosting.
great.
And I'll just echo that and say, I know it can feel a little bit like trying to drink out of a fire hose when we talk about all the things you have to think about. You certainly don't have to go to your lawyer with the answers. So just kind of knowing the full context, you can talk through and reach the decisions over time.
That's great.
So it's definitely a solvable problem. And just thank you again for having us.
Excellent. Thanks, everybody.
Excellent. Well, thank you all. I hope you all have a wonderful evening. And again, keep your eye on your inbox tomorrow for our evaluation and the links to the slides and the recording. And I hope you'll tune in next month, beginning of June, for Boating Safety 101. The boating season is just around the corner. And so have a lovely couple weeks. Be safe, and we'll see you again very soon. Good night, everyone.
Good night.
Thank you.